Well, good morning, guys. Today is the day that we wanting to educate you guys in terms of what we talk about, which is trademark. And I have a chance to actually meet this beautiful woman in the same community, which is the National Woman Entrepreneur. And we had a chance to kind of like chit chat a little bit, and we would invite her here to really actually educate you guys in terms of about trademarks, and there's a different topics. I would like to introduce you to Ilona Anderson. She is Florida-based attorney and specializing in trademark law and employment law matters. As an attorney with nearly 20 years of experience and founder of Cabot Dim Law Firm, she's combined legal experience to help business leaders protect their brands and minimize legal risks. Her practice focuses on helping founders navigate the complexity of trademark law and employment compliance, translating legal concepts into strategies that actually work in the real world. She is passionate about demystifying the law for entrepreneur. She has built her practice around educating business owners on the step they can take today to safeguard the most valuable assets, which is their brand, reputations, and their relationship with the employees. Whether advising on trademark registrations, employment policy, and risk mitigation strategies, she's prioritized clarity, efficiencies, and practical solutions. So whether she presenting a startup founder, supporting an established business, or sharing insight on her podcast for conscious founders, her purpose remained the same. Empower good people to build extraordinary things. At the heart of all, she believes that when you protect what matters most, you create space for your vision to flourish. So help me to welcome Ilona Anderson.
Thank you so much. Thank you for your kind introduction. It's so great to be here today with you, and I'm grateful for the privilege to connect with the audience and share more about brand protection.
Awesome. Well, thank you so much. So before jumping in, like educate the clients, we would like to kind of learn more about you. And if you want to share your background, how did you actually become attorney and what made you do the work you do today?
Yes, absolutely. So I know that a big portion of your audience is immigrants, and I am an immigrant myself. I came to the United States from Russia in 1996. I came on a high school exchange program. It was a scholarship program, so I didn't get to choose the states. So I didn't know until the last minute where in the US I would be going, and I ended up being sent to Alaska. So I spent my exchange year in Anchorage, Alaska. A wonderful host family that are absolutely amazing, and we're still in touch. Before returning back to Russia, I got admitted to the University of Alaska in Anchorage because I wanted to have an option to come back to the US on a student visa. I already knew I wanted to live in the US at that point. And so I came back to the US, got my double bachelor's degree in political science and foreign languages, and then moved to Miami for law school, and now have been practicing law for nearly 20 years.
Awesome. And I think most of you guys been watching my channel. You guys really actually not only entrepreneur but immigrants around the world who want to move to America. And the reason for me to invite Alona to be here because she's also immigrant herself. And you can hear from her story. She came here to the US when she was like 16, and she been living in the US, and because of her background she was able to understand the difficulties and the obstacle of how difficult it is to start a business in America. So for that, I feel really resonate with her story, and also want you guys to kind of connect with her in personal level because she was immigrants, and right now she's doing the work to help back to the community, and especially from her country. Like pleasure to invite her here and like really educate us in terms of not only about employment laws, but also the most important thing, which is how you start a business and protect your brand, not only in America, but also international. So for that, let's jump in to let her taking away to really educate us how to actually start briefly a business and protect your brand when you're starting out in America?
Yeah, absolutely. So, having spent most of my career or a large portion of my career being a litigator, and I still litigate a fair portion of cases, I've seen, well, and litigation just means you are representing a party in a dispute. Those could be employment disputes, those could be commercial disputes between business owners, disputes between partners, between employees and employers, between vendors, contractors, etc. So, having been a litigator for so many years, made me realize how many of those issues are really preventable. So when I launched Carpe Diem Law Firm, it was really with the intention to be there for founders early on to help them prevent issues that lead to litigation, because most problems are preventable. Whether we're talking about brand protection, registering your trademark early so that you don't have to be at risk of receiving a cease and desist notice and be then dragged into an infringement lawsuit, or whether it's employment law compliance so that you are properly paying your employees minimum wages, overtime, properly classifying them so that you don't have to be dragged into expensive litigation for overtime wages, unpaid wages, employment discrimination, etc. I wanted to help founders and entrepreneurs prevent that expensive litigation that can be prolonged, cost a lot of not only money, but also, emotionally be taxing. So if we talk about trademarks are something that every founder, whether they are coming to the US from another country or whether they are US based already, but any founder launching a business in the United States should be thinking about trademark protection. And that's because your brand is your business asset. As a business asset, it needs to be protected because number one, you don't want anybody else to infringe upon your brand. And number two, you need to have reasonable confidence that you are inadvertently not infringing upon somebody else's brand. And what I often see happening is that entrepreneurs are very excited to start their business. They pick a name, business name, or brand name, or a product name, or slogan that they fall in love with, and they immediately start selling products under their name, selling services under that name, selling courses under that name, etc., putting it, creating branded marketing materials, website, etc. And perhaps they've done a cursory Google search, perhaps they've done a cursory USPTO search looking for exact matches, perhaps they were able to secure a domain and a business name through the state Secretary of State Division of Corporations, and they think that's good. I own it. I'm in the clear. Then the brand name is mine. And that could not be further from the truth. Just because you have a domain, just because you have an LLC, doesn't mean that you potentially could have the rights to the brand name that you have created or that you have come up with. So attorneys like myself, before applying for federal registration with the US Patent and Trademark Office, we conduct what's called a comprehensive clearance search. And the reason that comprehensive clearance search is important is because it allows us to identify any possible conflicts that could either be impediments to registration or could pose a problem down the road because we discover if somebody else owns a similar brand. And I think what a lot of founders don't realize is that brand names don't have to be identical to pose a likelihood of confusion. So just because you looked for identical matches on Google, or just because you looked for identical matches on uspto.gov and you didn't find any, doesn't mean you're in the clear. The US Patent and Trademark Office looks at trademarks from the eyes of the consumer to see what might pose consumer confusion. And so if you have different spelling variations, if you have different phonetic variations, if you have foreign translations, if you have singular versus plural, if you have words that are arranged differently, or even different words altogether that may make the same commercial impressions, all of that could potentially be a reason for your trademark registration to be denied, or for another brand that's similar, that's already exists, to force you to rebrand or to force you into litigation. And this is where I come in, and attorneys like myself, we help you arm with knowledge early on so that before you start investing money into your brand, you can have reasonable confidence that you can actually own it and that you're not infringing upon somebody else and that you're not likely get sued for infringement from another brand.
Awesome. So in terms of, can you please explain to the audience, like, kind of like basic process of how long did it take, how they started, and what are those, so they can actually like imagine how comprehensive it is, and only in your level able to do that instead of they try to do it myself.
Yeah. So the trademark process can look deceivingly simple, right? Because a lot of people do attempt it on their own because you go on uspto.gov and you don't have to have an attorney to do it. You can do it yourself. A lot of people choose to do it themselves, or they choose to use some of those very basic trademark filing services. They can do it for a very low price, but they're kind of mills that really do not make any guarantees, don't have any accountability, don't help you deal with any rejections, and don't do comprehensive clearance searches to ensure that your brand is available. So, and the laws in the United States, trademark laws in the United States, tend to be more nuanced than trademark laws in other countries. So let's say if a founder is coming from another country to the United States and perhaps they already own a brand and maybe even have a trademark in another country, they've gone through the process, they think they understand the trademark process. That same process will not necessarily apply to the United States. In other countries, for example, in many other countries, for example, you don't have to submit what's called a specimen, which means proof that you're using your brand in commerce. In the United States, you have to do it, not necessarily right away, but at some point before trade registration is issued, you actually have to show the US Patent and Trademark Office that you're using your brand in commerce. So you can't just apply in a vacuum and say, okay, I want to own this brand, and receive rights to that brand. Another difference between many foreign trademark laws and US trademark laws is that you can be a lot more ambiguous in your description of the goods and services for which you're applying for a trademark and have much broader coverage and categories. In the United States, your application has to be very specific as to which goods and or services you're planning on using in connection with your brand, because although you can own a trademark indefinitely in perpetuity as long as you're continuously using your brand in commerce, you don't own it in a vacuum. You only own it in connection with specific goods and services. And this is why we can have, for example, Delta Airlines and Delta Faucets, right? They're both Delta, they're both trademarked, and although there was a bit of kind of back and forth between the two brands. Eventually, both registrations were allowed to coexist because the services and goods are in completely different categories. So which this is why I recommend using an attorney, because the process could seem deceptively simple. You just go on the USPTO.gov and fill out some forms, but the lawyering really comes from understanding what constitutes a good brand, how likely is it to be denied or rejected versus approved, and conducting a comprehensive clearance search to see, kind of have that a bit of that crystal ball to see am I going to experience any problems down the road. And why this is especially important is because the trademark process is long. It takes about close to a year. So from the point when you submit your trademark application, it takes about 6 to 8 months for your file to be assigned to an examining attorney at the US Patent and Trademark Office. And then at that point, they'll look at it and maybe they issue an office action, which means some kind of communication that maybe, it could be something minor, like we want you to do a disclaimer or amend the description of services or provide a clarification or something. Or it could be something major to where it's a preliminary refusal to which you need to make a legal argument and maybe, submit a 20-page legal brief with case law. And altogether, the process takes about 12 months. And so while no attorney ethically can guarantee success, when you're working with an attorney who knows what they're doing, who conducts a comprehensive clearance search, who can advise you of your risk so that if you need to rebrand, you can rebrand early before you waste money on the application and waste a year of your life waiting for a decision from the USPTO. It's one of those situations to where an ounce of prevention is worth a pound of cure.
Yeah, that sounds really comprehensive already. And then most people, if they try to do that, and then I always hear like at the beginning, feeling and everything, it's really simple. And then let me recap a little bit. So when the trademark files and then it's go through examining, like assign, and then under review periods for around, you mentioned 4 to 8 months or so. And then if they get either approved or not approved, they can go a longer process and then they have to submit certain paper required on that. Usually, if they get accepted for the files,
Mhm.
then is that how long did it take and what is the process for that? And if it no, what is the obstacles and is that longer for them and back and forth or what exactly?
Yeah, so the normal process through approval takes about 12 months. So about 8 months until the file is actually looked at by the examining attorney at the USPTO, and then a few more months to go through various formalities, which could be responding to office actions, providing additional information to the examining attorney, submitting a specimen, and I'll talk about specimens in just a minute, but that's proof that the trademark has been used in commerce. And it also could be well, so when the trademark is not approved, but approved for publication, which means that the examining attorney determined that there are no conflicts and the application meets the technical requirements, the USPTO then publishes the trademark in a public register. It's called the Official Gazette. Sort of let the public know that, okay, we're about to approve this brand. If anybody thinks that there is a reason that this trademark should not be approved because it conflicts with your brand, you have 30 days to let us know. And this is when other brands can file their oppositions during that 30-day period. This is kind of like at a wedding, if the priest would say, okay, if anybody opposes this union, speak now or forever hold your peace. So kind of that thing. Although within the USPTO context, you never forever hold your peace. You can always oppose it like later on through litigation. And then after that 30-day period, if no opposition is filed, then the trademark registration is approved and becomes official. Now, let me give you a caveat because there's two different types of trademark applications. You have what's called a 1A application, and that's the application when your brand, the founder's brand, is already in use in commerce. And you have a 1B application. This is what's called the intent to use application. So this is when you know you're planning on launching the brand, you're not using it in commerce yet, means you're not selling your products or services to the public yet, but you want to secure the registration as soon as possible. Why? Because the sooner you file, the sooner you have your priority rights. If I file today and my competitor files a similar application tomorrow, and we're both filing the intent to use application, then I have priority rights over my competitor, even though neither one of us has launched our services yet. My application has priority. So this is actually a very good word of advice to most founders that if you have reasonable certainty that you're going to be launching your brand sometime in the next 2 to 3 years, you can go ahead and file your 1B application. Now, the application cannot be approved until you submit evidence that you are now using it in commerce, but you can obtain 5, 6 month extensions, effectively giving you up to 3 years to really launch your business. So, if you plan on launching sometime within the next 3 years and you've identified your brand name and your core category of goods and services, the earlier you apply to better to secure that priority rate. But of course, in that case, the application itself will not be approved until you've submitted evidence that you are using it in commerce. So in this case, it wouldn't be necessarily 12 months, it would be up to 3 years, until you're ready to submit evidence that you use it in commerce.
That's actually really good advice that you break it down the difference between in use or sales and intent
Mhm.
to use. Because if people don't know that part and they just starting and they was like, I want to keep this, and that really helped them, especially early entrepreneur and founders when they just literally have that idea. So what is your suggestions in terms of, I know, there's some phrases in order for them to launch the business. Then there are a lot of entrepreneurs out there, they don't have much capital, so they would do it yourself kind of logos, slogans, and even the brand. When would be the good time for them to either like, okay, I do like this, but I'm not sure that it's on the market yet, but I want to protect this. When would be a good timeline for them to even file intent to use in order to protect everything? And then from there, you can suggest like this is already used, so you change it or you keep it.
Yeah. So I understand that capital or funding is often an obstacle for or an impediment for many founders, right? They're bootstrapping their businesses. They have so many other business expenses. So trademark expense is just one more expense for their business. But I would highly recommend filing before you start putting money into marketing. Because the moment you start marketing your business, and then if you decide to file for a trademark later on and you find out that your trademark registration cannot be approved, then you have to spend money on rebranding. And on average, it costs $30,000 to rebrand, and it costs in the six figures to protect yourself in an infringement lawsuit. So $30,000 or $100,000, it's a very big difference from $2,000 to $3,000 you may spend on doing it right on the front end. So trust me, this is really money well spent. And if you can't afford to have an attorney, use an attorney to apply for federal trademark registration, but you were considering, solidifying, figuring out what your brand name is going to be, at least invest in a comprehensive clearance search and legal opinion letter from an attorney. Because at least the attorney can tell you, okay, we've conducted a comprehensive clearance search, we assessed the risk. This is the likelihood that your brand will get approved. And or conversely, okay, here are all the risks and all of the competing brands that exist, based on the federal register, based on USPTO register, as well as based on common law. There could be brands that exist that may not have a registered trademark, but they're already doing business under that name. So if you get on their radar, eventually they'll probably drag you into litigation or force you to rebrand.
Yeah, it's already seemed like a lot and overwhelmed, and I think this is like help them a lot. But I just want to actually ask for the intent to use, what can you provide to the founder know that it's like what protect them from this early stage in order for like, okay, your brand is secure, but what's in there? So and then also if they file something with you and then, going through submissions or USPTO. Will
Mhm.
they able to change their logo design after they submit it, or they have to keep as it is? So
Okay, so that's a very good question because there's certain things you can change after the application and certain things you absolutely cannot change once you submit your application. So if we're talking, so with trademarks, you can file for what's called a word mark, where you're just protecting the wording of your brand, or you can file for a design mark, which is your logo or some kind of visual representation of your brand, even if it's just the wording in specific colors or specific fonts. Ideally, you want to apply for both because you want to protect your brand name, actual name, and your logo. If money is a consideration, then in the vast majority of cases, and there's some technical nuances where I could make a different recommendation on a case-by-case basis, but for the vast majority of founders, most of the time, I would recommend protecting the word mark first because it gives you the broadest protection. Because when you protect the brand name, the actual wording of the name, it becomes, and registration is granted, it becomes protected irrespective of the colors, irrespective of the fonts, irrespective of the visual representations. So it gives you that broader protection. Logos or design marks are a bit more tricky because the moment you change your design, even a little bit, or you adjust your colors, you lose that brand protection. So I don't recommend protecting your design marks until you've fully solidified your design. You're not going to be, messing around with it, tweaking it, changing it, because if you change it, even if you change the colors, unless you obtain protection in black and white. So then it becomes protected irrespective of the color, which is also an option. But if you protect a specific design and specific color, if you change it, you'd have to apply for a new trademark and start the process over. So that's one nuance to keep in mind in terms of word marks versus design marks.
Got it. Also, another question, some founders when they actually like have their brand design, which is some people only know basic stuff. Some founders never actually go to school and fully understand what should be included in my branding. So I would say, I would like to ask what kind of files or documents or what exactly how many pieces of whatever their brand that they need to submit it to the attorney in order to get filed and submit it to protect their brand.
Certainly. So to protect their brand, we don't need like a brand kit or a style guide or anything like that. We just need the name or the logo, depending on whether it's the word mark or design mark. We need information about the founder or the owner of the trademark, which could be an individual on, or an LLC. I always recommend registering the trademark in the name of an LLC for two reasons. Number one, it becomes a business asset. It can be assigned, licensed. It survives you if something happens to you, if it's part of your business. And also because once the registration is applied for, it becomes a public record in the USPTO records. So most people probably don't want their home address appearing in the records. And, there's scammers and this and that. So usually applying in the name of LLC and using your business address is advisable. There are also certain questions that you would have to answer to see if your brand name means something in a foreign language. And if so, what is the meaning? Or if your brand name is based on a living person's or dead person's likeness, then if you have the rights to use that person's likeness or to use that person's name. And then you would have to provide a description of goods and services. The USPTO basically has an ID manual from which you can pick and choose your description of goods and services. Most goods and services in existence are covered in that manual. However, your business is so unique that there is no description that already exists, then we can create a custom description and submit that to the USPTO. And then you will have to, once we're submitting your specimen, which means proof that you're using your brand in commerce, which could be, for a 1A application would submit it right away. And then for a 1B intent to use would submit it later on once you are actually using it. Usually it would be usually the best specimen is a website screenshot that shows that you're in business and that you're actively selling your services. But it could also be if it's a physical product that's sold in a store, it could be a picture of the product on a store shelf and could be product label showing, essentially like the batch or not the QR code, but the item, the stock code, from the factory, etc. So anything that basically shows that your product is available commercially. And so, obviously I or your attorney of choice will help you figure out what is the best specimen for your specific situation. And then you'd have to read through and check a bunch of boxes with various disclaimers that to confirm that you're not engaging in fraud, that all the information you submitted is honest, that you're not, to the best of your knowledge, you're not infringing upon somebody else's brand. There's very hefty penalties for lying to the USPTO.
That's awesome. Well, thank you for sharing that. So I think I would like recap. It's the most important thing, which is the name, the logo, and their LLC or business to protect them. And the rest should be there's a whole checklist or a whole list for the clients when they reach out to you with that so they can prepare and ready to go to file the applications. But
Yes,
then
absolutely.
there are so many different classes and some people don't even know, but I think most of the founders when they start, for instance, either the clothing business or a service, anything, they would know there's a category under one that brand name. But
Mhm.
sometimes they are not aware there are so many different type and classes. Do you help them to really give them like, okay, do you need to file one more classes and how's that work for that? Can you please explain to the audience?
Yes, absolutely. So I'm very hands-on with my clients and help them make strategic decisions how many classes to file in. So To just to clarify, classes are basically categories of goods and services. And so let's say if you have a podcast, maybe the primary class will be 41, which is entertainment, but there could also be another class for downloadable videos if your podcast get downloaded, and maybe there could be another class if you're selling branded merchandise, and there could be another class if you're doing like live events and for example, for even for branded merchandise could be different classes because there was one class for clothing and hats, but there would be another class for mugs and bottles. So when I first meet with founders and before I endeavor to do a comprehensive clearance search, I always have a discussion with them and I ask them, okay, what is your vision for your brand? Let's say in the next 2 to 3, maybe even 4 to 5 years. I understand that, let's say your core service is a bakery, but what else do you see your business doing in the next 3 to 5 years? And I gather that information. And when I conduct a comprehensive clearance search, I include those additional classes in my search. So I can, again, it's kind of like trying to have that crystal ball. It's not 100% accurate, but it gives you an idea because if the founder says, okay, 100%, I want to sell, I don't know, some auxiliary service within a year. And we see that there's no conflicts for the primary class, but there's clear conflicts for the class that they're envisioning selling services or goods in the next year or so. I want my clients to know about it in advance so they can decide, okay, that's maybe not a big deal because this is kind of in a someday maybe category. Or, okay, this is a deal breaker for me, and I definitely need to rebrand because I want to move forward with a brand name where I'm cleared in all of the classes. So that's part of the comprehensive search. And then when we actually do the filing, it's really case by case analysis. And it also depends on the client's budget as well, because the USPTO charges a $350 filing fee for each class. So that means if you, sure, I mean, yeah, you could potentially file in your intent to use in 10 classes because you have this big vision for your business, but maybe the extra $3,500 is not something that you're in a position to spend in filing fees alone. So for some brand owners, it's a financial consideration. For some brand owners, it is more strategic in a sense that they want to secure it in a primary class first and make sure that there's no issues. And then later on, as they get their business going, they come back and then we file a separate application for additional classes. It really depends on many factors from, strategy, how certain they are that they're going to be launching in different classes, and how far along they're planning, right? Because remember, you can only obtain 5 extensions for your intent to use applications, your budget, etc. So I sit down with every client and help them make that strategic decision based on what makes sense for them.
Awesome. And then how many search actually will you include in your service? Because sometimes there a lot of attorneys out there will like, we do one search and if it's this and we not. So how's that work for your firm?
Yeah, it's a really good question. And I want to be very fair to my clients because if I deliver bad news to them and say, I'm sorry, but your brand is not available or the risk is just too high. I mean, obviously, if they're serious about their business, they will want to come up with a different brand name. And I don't want to charge them for that. So, as part of my trademark package, I include a second search at no additional cost. So, basically, if the first search comes back as brand name being unavailable or high risk, then they can give me a second brand name to search, and I will do a second comprehensive clearance search and a full-blown legal opinion letter assessing the risk at no additional cost.
Awesome. That's really amazing. And then I think that will help all the founders have a peace of mind. And also from what you just shared, would highly recommend it. Most founder will have their first baby name and that they really in love with, but also have the second options that, in case anything doesn't go in the right way, at least they have that not spending extra time to do and hope the first one will go right.
Absolutely. And also, the other thing I want to mention is that sometimes I see right away that the name is going to be a problem, because I'll do an exact search in the USPTO.gov, and if I see that there's already an exact match, a very close match, you know, I'm not going to charge my clients and go through the whole process, just for show. I'm going to tell them this is not going to work. Let's start with a different name. Or if I see that the name is too generic. So the US Patent and Trademark Office likes names that are unique and arbitrary, but not names that are merely descriptive or overly generic. And that kind of creates an entrepreneurial dilemma because as entrepreneurs, we want our brand to clearly communicate what it is that we do. But from the perspective of the US Patent and Trademark Office, if your name clearly describes what you do, then you're likely using very generic language and they don't want to prevent other similar brands from being able to use that as well. So you can't trademark delicious food for a restaurant or beautiful nails for a nail salon because those are just very generic and descriptive terms. But terms like Kodak that are just made up names, those are great terms. In terms of like Apple, that is a known name, but it's the connotation is not what you normally would think of as an edible apple, but it's in connection with software or computers or hardware. Those are good names as well. So again, if a client comes to me and says, "Hey, I want to trademark New York style pizza," well, sorry, I'm not going to waste their time and make them spend money on a comprehensive clearance search. In my advice, if I can clearly see that name is too generic to be trademarked, and I will explain to them what makes a good brand name and advise that they come up with an alternative. So from the moment we file, I mean, like I said, no attorney can give a guarantee that it will be approved because USPTO examining attorneys have a lot of discretion and the law is very nuanced. So the best we can do is speak from our experience and conduct a comprehensive clearance search and let them know that there's low risk of rejection, medium risk of rejection, high risk of rejection, and the reasons why and what could be possible conflicts, right? From the point in time when they hopefully receive their approval from USPTO, the USPTO issues a registration certificate. And so once they have that registration certificate, they can start using that coveted circle R next to their brand name to let the rest of the world know that, okay, my brand is protected. I'm putting that stake in the ground, hands off, I have enforceable rights here. Now, it doesn't mean that you can't use their brand name, your brand name until you have that federal registration. You can still use it. You just don't have the protection. And you can still use the TM. And TM kind of lets people know that, okay, I don't have federal registration, but I'm serious about my brand. I'm claiming it. But you can't use the circle R until the certificate of registration has been granted. Now, trademarks also have to be maintained and renewed. So you have to submit a maintenance filing between the fifth and the sixth year to the USPTO, letting the USPTO know that, yes, I'm still using my brand in commerce and, check a bunch of boxes that basically say, yes, I've had continuous use, et cetera, et cetera. And then you also have to renew it between the ninth and the 10th year, and then every 10 years thereafter. Your attorney will docket all those deadlines and send you a reminder. Or if you're doing it yourself, which again, I don't advise, but I understand some people will do it anyway, then you'll get a communication with the USPTO for the reminder. If you blow that deadline, however, your registration lapses. It's very difficult to revive it. In some cases, you might be able to revive it if you act swiftly within the first 3 months. But beyond that, you lose all rights. Even if you've owned your brand for 10, 20, 30 years, you lose all rights and then you have to start over. And there's no guarantee that it will be approved at that point because, there could be other brands that have swooped into the marketplace between then.
I think I just catch some really good what you just shared. For the first one, the most like the best feeling for founder is when they file the trademark so they can claim that TM without the circle outside. And I didn't know that difference actually on their brand. Like I'm already trademark mine, like
Mhm.
proud and put on their branding or social media. Until everything approved, then they can actually have that TM. And also for the second part, which is the day that they have to file after the deadline of the 5 years, they, as a founder, they have to remember not attorney standpoint because I would say their business is not attorney business. Is that correct?
Yes. So, just small clarification on point number one. You can use TM even if you didn't file for federal registration.
Oh,
So, any founder basically claiming their brand as theirs can use the TM, but the Circle R can only be used after registration has been granted.
got it.
In terms of the renewals, yes. I mean, if you have an attorney, the attorney, it is the, and you've retained that attorney, it is the attorney's obligation to monitor your trademark and send you reminders of any renewals, assuming that that's part of their contract. Some attorneys say, I file and that's it, that my service ends. So you'd have to look at the attorney's engagement agreement and see. But yeah, if you're doing it on your own and you don't have an attorney, you don't have anybody to remind you except the USPTO. But if you changed your email address and you didn't update it with the USPTO, it's easy to blow that deadline. I mean, I had recently happened to one of my clients. Their attorney did not have the monitoring as part of the contract, and they didn't get notice. So they've been in business for, I can't remember exactly, but probably at least 10 years. So they've had their trademark for at least 10 years. I think it was the renewal that was up between the ninth and 10th year that didn't get filed. They didn't realize it until 6 months later. So at that point, they couldn't apply to revive it. And they wanted to refile their trademark. And when I conducted a comprehensive clearance search, at that point, there's so many other conflicts. There were so many other similar names that, they're still deciding if they're going to move forward or not, but it's very high risk at this point. So.
So what is the timeline for like minimal risk that, okay, if you miss in just maybe a month until like 6 months, it's like a big red flags. Is there?
Well, I mean, don't miss because it's not, there's no guarantees that you miss. The USPTO gives you a bit of a grace period because they give you a window during which to file, and they give you an additional window to where you can pay a penalty and still file. But then if you are outside of the grace period, they cancel your registration. Under some circumstances, within 3 months, you can apply to revive it, but it's not guaranteed. Not everybody who applies to have their trademark revived will have their revival application approved. So, like, my best recommendation is just comply with the deadlines. And then after that, you have to start process from the very beginning. It doesn't matter how strong your brand is, how long you've owned it. If the registration is canceled, you have to start the process over from scratch.
I'm not sure that you mentioned the grace period time,
Yeah, grace period, if I'm not mistaken, I think it's
6 months. And then can you tell the audience difference between the penalty that forgot to file and then the process of like file again? I'll probably it's like file again will take a year longer and then more
if you file
expensive.
it, yeah, if you file again, it'll take a year longer, it'll be more expensive, but also when you originally filed, there might not have been any conflicts. Now there could be other conflicts, other competing brands that have appeared in the marketplace. So there's no guarantee that it will even be approved.
Wow.
Yeah.
So have you seen any worse scenario that people in business for a long time and forgot that part and then losing their whole business right or brand?
I personally, other than that scenario which I shared with you where they lost their registration and now approval of the renewed registration is unlikely. I haven't personally had any clients who lost their business as a result, but conceivably it could happen because one of those new brands, as soon as you apply, can now file an opposition, or they can send you a cease and desist notice, or they can drag you into litigation and basically put you out of business or force you to rebrand. They're not going to put you out of business, but rebranding can put you out of business, or litigation expenses can put you out of business because, like I said, those lawsuits could be in the six figures.
Yeah, I'm so glad that we have this conversation because we just want to make sure that educate you in terms of this. Do not miss the deadline. If you do, you have the race periods, which is she mentions around 6 months, but you don't want it to start over again after on top of the hills and now to have to go back and climbing up again. So this is really useful and valuable information. So I have a a follow-up question. It's what exactly is included in your trademark service fee?
So currently, and from time to time I modify it. So depending on where you're listening to this, there could be slight modification, but currently what it includes is unlimited consultations with me. Like I said, I'm very hands-on with my clients and very available to answer any of their questions. The comprehensive clearance search and legal opinion letter. Like I said, if the clearance search comes back as identifying too many conflicts, so too risky, then I will do a second clearance search at no additional cost and provide the next opinion letter. It includes the preparation and filing of the trademark application, filing fee for one class. It includes responses to all of the procedural office actions from the USPTO and up to 1 hour of responding to substantive office actions. And after that, it rolls over into hourly. And the reason I don't include the entire response to substantive office actions is because that allows me, it doesn't happen in every case. It doesn't happen, most of the time it doesn't happen, or maybe in more than 50% of the cases it doesn't happen, and allows me to keep the package pricing very reasonable. And then, substantive response to an office action, that really means that there is a preliminary refusal from the USPTO and you need to provide a legal brief and legal argument. And in some cases, those responses could be pretty straightforward and take a couple of hours. In some cases, they could take 10 hours in more complex cases. So it's more fair to me and to the clients if after 1 hour it rolls over into hourly.
Awesome. Sin, can you please provide like general informations for the founder to know? It's like, is that the service, your service fee, it's breaking down into one-time payments or are there certain payments or has it work? And also for just the USPTO fee itself, not including yours, what is the kind of brief and how much or that so they can know and repair in advance and that was one-time payment from the government.
Okay, sure. So currently, my fee is $2,800 for the whole package that I described, which also includes filing fee for one class, $350 filing fee for one class. If the client decides to file in multiple classes, then there will be a $350 filing fee for each class, so I would have to bill them additionally. Now, this is not my fee, this is the government fee. This is the fee that the USPTO charges. That's not the money that I keep, that's the money goes to the government for processing. In some situations, as I mentioned, sometimes founders are not sure if they want to move forward with registration. They just want a comprehensive clearance search. Yeah, I think I covered, I mean, there's some situations where there could be additional fees due from the government. For example, if we file a 1B application, which is the intent to use application, and then we need to submit statement of use, proof of usage later on, the USPTO charges $150 filing fee for that. I don't charge additional attorney's fees for that, but the government charges additional fees. So there's some scenarios if we need to make an additional filing or if we file for an extension or things like that, there could be additional fees involved.
Yeah, that's actually amazing that you break it down into if you only want to search, this is the service. So at least people not spend the whole package without like, if I'm not get approved, then I don't have that type of money. But you do have that. And then if they decided to move forward, then they can actually pay the balance for continuing the process. And then I think the other question is like, deciding with the file class, which is already included in your fees for the first one. It's like the whole documents, whatever extra, maybe another like couple thousand. Is that additional cost from the government or just that one thing that they should be aware?
So the government charges, and again, their fees are subject to change. They just went up last year. I don't anticipate they'll probably increase them for a couple of years now that they've increased them last year. So for now, it's $350 per class. So if the client decides to file in, let's say, three classes, then the first class is covered as part of, the initial the package price that I offer to them that they prepay, and then I would have to invoice them additional $700, 350 times two, right, to cover the additional filing fees if they decide to file in multiple classes.
Okay, got it. So it's only that fees that they should be aware of, which is additional class. There's nothing else more.
Additional classes, and then if we're filing the statement of use separately, if it's an intent to use application and we're filing the statement of use subsequently, then there's also the government fee to file the statement of use. And if we're filing extensions, I can't remember what the extension fee is, but I think it's around $150 as well to file for an extension.
Okay. Yeah, so so you guys not to like I was like worried too much. I'm like, oh my God, if I spend attorney fee, then it's another charge for a couple $1,000s from the government fee, then now they don't have that type of money. But thank you
Yeah.
so much. I think the fees is one of the most important thing for founder to know from the early stage because but then there's avoid a lot of legal process and then going to the whole branding that she mentioned from the beginning that costs you another rebranding for around 10 to 30 grand because it's super expensive for people to design everything. So I think this is like the most important step that most founder, if they have, at least you spend the fees for, Ilona to do it's like a deep search, make sure that you're moving forward or not before spending another week or so trying to hire people to do designing and then you have to do it again. So
Yeah, sorry, I didn't mean to interrupt you, but I wanted to chime in and say that remember the rebranding fees or costs are a lot more than just redesigning the logo of the website because you could also be losing a bunch of merchandise. Let's say you've had branded merchandise manufactured, you have your product with your label, you have your packaging with your label, you have products out there. If you're forced to rebrand, you can, because you received a cease and desist notice, then you can no longer sell that merchandise with your old branding. And so you lose everything that has been already created and manufactured for you, and you have to start over. It goes beyond just the logo.
yeah. And also, do you actually assist the clients beside the filling and all that if they are not a party actually challenge their trademarks or
I personally don't do litigation in the trademark context. I do litigation in the employment law context, but I don't do it for trademarks. So for trademarks, I focus on prosecution. That means comprehensive searches, that means registrations and office action responses. I will send cease and desist notices and try to negotiate, some kind of an agreement. If my client finds that somebody's infringing upon their brand, I will send a cease and desist notice on their behalf and try to work it out with the other party. But if things escalate and things cannot be resolved amicably, then I would refer them to an attorney that specializes in trademark litigation, part of a very extensive network of very talented attorneys. So I would make sure that there's with somebody who would take great care of them.
that's awesome. And we have this question. So now, if Ilona not able to really assist you with this, she's already have a lot of good hands and then good connections with different attorneys. So you'll be in good hand to really, take your matters to somebody else that suggested. So do you actually handle any office actions or disputes?
Yeah, office action. Yeah, I do respond to office action. So I handle everything from the initial intake through registration, so office action is part of that process. And then if post-registration, we find out that another brand is infringing upon my client's brand, I will send a cease and desist notice and try to negotiate a resolution. But beyond that, if we need to, file an opposition with the trademark trial and appeal board, or if we need to bring a lawsuit for infringement, that's when I would hand it over to one of my trusted litigation colleagues.
And then I would like to know, is that your office actions included in your service or billed separately?
So all of the office actions that are procedural, meaning that the examining attorney needs a clarification, or maybe they want me to revise the description of goods and services, maybe there's a disclaimer needed or something like that. All of that is included. When it comes to substantive office actions, which is basically preliminary refusal, and I would need to make an extensive legal argument. Up to 1 hour of that work is included in my package. And then if it takes more than an hour, then I would bill my clients hourly.
I think we kind of cover a little bit of like the process, the filling, applications, and classes, and also a little bit of office actions. I know we just talked office action, but can you actually provide a riff, educations or theories for the entrepreneur or founders to know what exactly that
Yeah. So office action is basically communication from the USPTO that something needs attention and something needs to be corrected. And sometimes it's something very minor and sometimes it's something very major. And I would tell them that if you receive an office action from the USPTO that's a 2D, two parentheses D under section 2D, that means that the examining attorney determined that there is a likelihood of confusion with another brand. And basically, they've decided that they're going to reject or decline your registration. And you're given 3 months to respond to the office action, and you can obtain one 3 month extension. So you can take up to 6 months to respond to the office action. If you receive a 2D office action, I suggest don't try to do it on your own because it requires complex legal argument. So if you've DIY'd your application up to this point and you receive a 2D office action, do find an attorney to help you with that because if this is your one chance to overcome the examining attorney's decision not to approve your trademark. And so you want to use that one chance wisely and create a compelling legal argument with legal precedents and proper citations. Because if you blow it, then your registration is denied. And then, yes, you can appeal it, but appeal basically means litigation. You have to go in front of the Trademark Trial and Appeal Board. You technically, I mean, yes, you could do it without an attorney, but it's a very complex proceeding that it's not recommended to do it without an attorney. It's very expensive, and most of the decisions made by the examining attorneys are affirmed at the Trademark Trial and Appeal Board. Yeah. And also same goes for a refusal based on your name being merely descriptive, your brand name being merely descriptive. Again, if you receive any kind of refusal, any office action that has the language refusal in it, hire an attorney. It'll be money well spent.
is anything you would like to share or educate clients in terms of like filing trademarks in the US before we jump into the next questions?
So, because I know you have an international audience, I want to make sure that filing in the US can also provide foundation for filing trademarks internationally. Once you file in the US, then within 6 months of your US trademark application, you can submit foreign applications in select countries. I mean, most countries. I can't think of any country that's not on the list under what's called the Madrid Protocol. It's a convention that allows you to do a simplified filing of trademark applications in multiple other countries within 6 months of your US application. The benefit of that is number one, filing date for your US application will be the same, or the filing date for your foreign applications will be the same as for your US application if you do it within the first 6 months. And second, you don't have to go to each country individually and hire a trademark attorney and follow their rules. It's like a simplified process. There is a fee for each country under the Madrid Protocol, but US application just provides kind of that doorway into other foreign registrations. Now, if you miss the 6 months trademark, you can still file under the Madrid Protocol, but your filing date will be the date of your Madrid Protocol filing and not the filing date of your original US filing. And then you always have an option to just go to each individual country and file there, but that's the most expensive option because you would have to get ideally, I mean, local counsel in each of those countries and spend attorney's fees on each of those applications.
I think we hear with this amazing educational video that, Ilona's tell you really details about which day, which deadline that you need to do and the name in order for you to save the most money. So you got to pay attention within 6 months. And you mentioned is the Madrid Protocol fillings, and this is applicable for all the country outside of US. Otherwise, after that, they have to do individual. So, in terms of that, do you handle international trademarks or Mandarin protocol filings for the clients?
Yeah, certainly. So I can handle filings under the Madrid Protocol, but if a client wants to file individually with each country, I would need to bring on local co-counsel. So basically a trademark attorney in those respective countries because I don't know their trademark laws and I would want to make sure it's done right.
And I think already here, from my perspective, the metric protocol is going to sound like it's something that most founders need to do in order instead of the other one, because it seemed comprehensive, and now they have to speak and stick to trademark attorneys in that country. So it's a lot of work. So, do you have any recommendations for the founders, like which country should they consider protecting first or file first if they do decide to individual?
Yeah, so you want to file where you are selling your goods and services or where you plan on selling your goods and services. And, reasonably also like strategically speaking, because you may say, okay, well, it's going to be a global brand, I'm going to sell everywhere. Where are you reasonably going to be in a position to really enforce those rights? You can make decisions about what the priorities are because, if you know that, I mean, yeah, it makes sense for me to file in China, but I'm not really going to take any steps to enforce my rights in China, then, maybe you don't want to spend money on the application. So those are again strategic decisions. Ideally, you want to protect your brand everywhere where your brand is being sold. But practically speaking, because as a trademark owner, it is your obligation to enforce your rights. So the US Patent and Trademark Office or other, local trademark offices in various countries, they make a decision if your trademark is approved, but they don't essentially police your brand. They don't enforce your brand. So if somebody is infringing upon your brand, it is your responsibility to send them a cease and desist notice or to try to negotiate a coexistence or to file some kind of an objection or opposition to their application or to sue them in some cases.
And how do expansions for their brand affect the US trademark?
Well, you mean expansions in the scope of goods and services or expansion? Okay. So if you file a trademark for a specific product or service category or type, and then you've expanding goods and services, then you'd have to file a separate application for additional classes. Meaning that once your registration, you can't go and add classes to a pending application. And then generally, because this brings me back to a question that I may not have answered fully earlier when you asked me to what extent can an application be modified? Usually, when you have a pending application, you cannot broaden the scope, but you can take things away. Meaning that, if you applied in multiple classes, then before registration is granted, you can eliminate some of the classes if you decide you no longer want to pursue registration in those classes. Similarly, if you've crafted a very broad description of goods and services, you can make it more narrow, more specific. But you cannot do vice versa. You cannot add classes or you cannot broaden the scope of goods and services.
Got it. Yeah, and thanks
So
for adding on that part. So, how do you ensure the trademark doesn't get canceled?
make sure that you file your proper maintenance filings between the fifth and the sixth year, and you make sure that you file your renewals between the ninth and 10th year and every 10 years thereafter. But also, you have to make sure that you're continuously providing goods and services under that brand, because that's one of the things that the US Patent and Trademark Office asks you to certify when you ask for renewals. They want to make sure that you're using your brand in commerce.
For the audience, would like to know is pretty much, do you specialize in all type of industries, limitations, and how many trademarks have you filed successfully?
Sure. So I'm fairly new to trademark law. I've been a practicing attorney for nearly 20 years. And like I said, I've done things that are very complex and all types of litigation, mostly on federal court. I only launched my trademark practice in about a year and a half ago. So my trademark portfolio is not that substantial at this point. And as far as, so I help founders from a variety of different industries. As it so happens, a lot of my clients have been kind of in the wellness space. I've helped file trademarks for a manufacturing company, a liquor brand, a cafe, insurance, retirement planning services, coffee, design. I mean, the scope has been very broad. So I've had clients all over the place.
Got it.
And also geographically too, because trademark law is all federal law. As a Florida licensed attorney, I can represent clients in trademark prosecution matters anywhere across the United States. So, in fact, most of my clients have been outside of Florida. You know, when I work with employment law clients, I work primarily with Florida-based clients because employment laws, yes, you have federal laws, but you also have state-specific employment laws. And I'm an expert on Florida employment laws. With trademarks, it's all based on federal law, and therefore I can work with founders anywhere across the US.
That's amazing. And also, I would say if they are internationals, would like to reach out to you, that there's no restrictions.
No, there's no restrictions. I mean, no matter where you are located, if you're looking to protect your brand in the United States, I can help you.
Awesome.
And beyond that, if you're looking to expand under the Madrid Protocol, I can help you. And then if you're looking to expand in other countries individually, I can help you with the help of local co-counsel.
Amazing. And then when the clients reach out to you, are you the main point of contact or you have the team to really help them? And then how often they will receive the updates from you or your team?
I'm very accessible and very communicative. Yes, I have staff that assists me. So it's both me and my staff as points of contact, depending what your issue is, right? If it's a legal issue, then of course you will talk to me, or as my team grows, it may be one of my attorneys, right? Depending on when you're listening to this, because, as entrepreneurs, we all grow. And so I may have expanded my team by then. And if it's, more of an admin question, such as, can I schedule a consultation? What is the timeline for this? How do I make payment? How do I submit documents? Then one of my non-attorney staff members will assist with that.
Awesome. Besides English is your language for the clients. Are there any different languages that you can assist the clients?
Certainly, I have Spanish speaking staff and I also speak Russian.
Awesome. There are three languages you actually can access to.
I mean, I technically speak French too, but I don't think my French is strong enough to necessarily discuss legal matters with clients.
There are three languages, and then English is the most common, but I think that would help with Spanish speaking and also Russian. So that's another advantage. And I think there's not much of people out there can have a staff and a team of three languages. So that's amazing to hear. I would like to actually jump to like closing because it's a time and your time is so valuable and we learn so much from you and even myself. Bonus questions for the founders who are watching this until the end. Are there biggest mistake you see business owner make with the trademarks and early on in the business?
Yeah, so biggest mistake number one is waiting too long. As I mentioned, by the time somebody gets around to protecting their brand, they may learn that it's not available. Maybe it was never even available to begin with, and they've already invested money into their brand or their product, and now they have to rebrand. Mistake number two, not conducting or not having an attorney conduct a comprehensive clearance search because it's like operating blind. You never start building a house on land that you have not made sure you had ownership of, right? So why would you basically start building a brand without the foundation of making sure you can actually own that brand? Even if you haven't secured it through formal registration yet, at the very least, start the process of conducting a comprehensive clearance search before you start putting money into your brand to rule out any possible conflicts and also get an attorney's opinion on the strength of the brand name and make sure it's not something generic or descriptive that you have no chance of protecting later on.
And then can you please share with the founders or viewers that how does their trademark increase their business evaluations?
Yeah, so intellectual property is an asset. And so if you're, first of all, with a trademark, you can assign it to somebody else for money, you can sell it to somebody, you can license it. And if you're selling your business and your intellectual property is protected, that increases the value of your business because your potential buyer can have confidence that they have the rights to your brand, and then they're not buying some ticking time bomb that will be dragged into litigation at some point down the road because they're infringing upon somebody else's brand.
It's going to help you to increase the business evaluations. And if you want to sell the licenses to or license to somebody else, that couldn't be a case. Have you ever seen anyone actually want to buy the brand name or the trademark after they do their?
Yeah, it happens all the time. And also, interestingly, I was being interviewed on a podcast by an attorney who was telling me that a number of years ago, he decided to trademark a specific brand. He filed an intent to use application because he was planning on launching that brand. The idea kind of fizzled and he never really did anything with it. And then he was approached by somebody who saw his pending application in the USPTO database who wanted to launch the same brand. And he bought that brand from him for, I believe, $30,000. So, basically, he was so thrilled because it was easy money for him. He came up with an idea, he decided to protect it, kind of fizzled. Next thing you know, somebody is knocking on his virtual door, offering money for that brand.
That's amazing. And I think that's the story that I heard before. And even some people even offer bigger money than that to even buy a trademark that actually haven't been starting a business or going to productions and all that too. So this is another benefits that you can see from filing early on without doing the work.
Yeah, and this is the thing. I mean, humans are emotional beings, and we get attached to brand names just like we get attached to certain other things that may have meaning or value to us that may be meaningless or valueless to other people, right? So when we come up with a brand name that we feel is genius, we get attached to it. And so if somebody else owns that brand, oftentimes we're willing to spend the money to buy it from them because it has meaning to us. And it's a double-edged sword because that also when entrepreneurs are very attached to their names, and I do a comprehensive clearance search and I see that their name is risky, sometimes they're pushing to apply anyway to kind of see what happens. And sometimes we apply and sometimes we get lucky because like I said, you like nobody can make any guarantees. I can tell you, and every trademark attorney, no matter how long they've practiced for, I hear the stories from my network over and over again that sometimes they apply for something that they feel for sure is not going to get approved, but their client is pushing for it, and all of a sudden gets approved. And sometimes they submit an application that they think, okay, for sure this is a clear path, there won't be any issues. All of a sudden, the examining attorney finds some kind of issue with it. So there's always outliers, unusual situations on both ends, but in the vast majority of cases, you can have some reasonable predictability and certainty which way it's going to go.
Amazing. If you have one last tips or recommendation to the founders, any level,
Yeah,
what would it
so
be?
that would be along the lines of not getting too attached to your name, to the name that you picked, and making a sensible, reasonable decision. I mean, unless you have money to throw away, but if an attorney tells you know what, that name is too risky, it's probably not going to get approved. Seriously consider coming up with a different name, especially if you're early on and you haven't invested into the brand yet, come up with a different name that has clearer path of registration. Yes, sometimes, like I said, you might get lucky, but chances are, if the attorney is telling you it's risky, you might waste a year, wait for the decision, get the inevitable rejection, and then start the process all over, with new fees, another 12 months waiting period. That's my advice.
Well, awesome. Thank you so much for sharing. And I think it's come to an end that it's like, we learned so much from you. And we would like to ask how people actually connect and find you. And also, I think we have a little bit some special for the clients who watch this with your complimentary 30 minutes trademark consultations. Can you please briefly share about that part?
Yes, absolutely. So you can find me on Carpe Diem Law or also Ilona Anderson on LinkedIn or Carpe Diem Lawyer on Instagram. And yes, I'm very pleased to offer a special package special deal for the listeners of this podcast. There will be a link, I guess, below or wherever,
Yeah.
right in the show notes, in the description that will have my Calendly link that will allow you to have a complimentary 30-minute consultation. I normally charge for consultations. I normally charge $199 for consultations. So you'll be able to get not only a complimentary consultation with me, but also a 20% discount on my trademark package services.
This is like really amazing, and that's really actually generous of you, especially for, founders and entrepreneur who starting their business. Especially this is, I would say, I haven't heard any attorney actually offer this type of complimentary for her time, her experience, expertise, and also the 20% for the whole package. And I would say from the standpoint of also like Philo, early founders, this is one of the offer that you don't want to miss, especially for New Year. You want to save money for something important, and because of this collaboration and this relationship that we connected, and I'm so appreciate for your offer to the audience. And I hope that they learn a lot from this, sections and conversations, educational video to use and really help them start their brand, protect their brands and their rights in the future from your generosity. And if there is any lasting you want to save, please send it away. Otherwise, want to thank everyone here for spending the time to watch the video, and also have amazing Happy New Year.
Absolutely. And since you mentioned the new year, we all make resolutions, get in shape, lose weight, work less, earn more, etc. Well, one of the things that should be on your New Year's resolution list is to protect your brand. So if you're serious about your business, you should really be serious about brand protection. So take advantage of the offer, have the consultations, no obligation. As an entrepreneur myself and as an immigrant myself, I want to be of service to any founders out there navigating business growth.